MAGA, Donald Trump, and big industry often goes forum shopping, making sure that their cases are not filed where they should be, but in friendly courts with friendly judges in friendly circuits in order to maximize the ability to obtain a ruling in their favor. And forum shopping is up on the chopping block with a new United States Supreme Court case involving RJ Reynolds, e-cigarettes, and vaping, and particularly whether forum shopping is going to be allowed by the United States Supreme Court or is going to be finally shut down. I'm Michael Popok. You're on Legal AF, the YouTube channel. Let's take a hard look at forum shopping, what it is, and what the United States Supreme Court is being asked to consider at a new oral argument just after the inauguration involving RJ Reynolds. Now, we've seen forum shopping play out writ large over the last 4 years of the Biden administration. Every time MAGA didn't like something that the Biden administration was doing, whether it were related to reproductive rights, voting rights, immigration rights, or any other kind of social program like student loan forgiveness, the MAGA and their followers would run to court. Except they wouldn't run to the District of Columbia court, which they thought was hostile to their interests, but that's where you generally sue federal agencies like the FDA and anything else. I mean, the D.C. Circuit Court or the D.C. Court of Appeals and the Circuit Court, sits in D.C. They would run halfway or more than halfway across the country and file in Texas, form lobbying groups in Texas in order to try to get to single judge districts in Texas, like in Abilene, Texas, and Amarillo, Texas, like Judge Kaczmarek. That's how we got out of from Texas to the Fifth Circuit to ban at one point mifepristone as a medication abortion solution for women. It's the Texas two-step. You go and file in Texas in front of a judge like Kaczmarek, then you take it to the Fifth Circuit, which leans heavily right, and you're off and running, maybe with a what's called a nationwide injunction or ban coming out of this little tiny case where the population is next to nothing, and yet it's now banned the constitutional rights of men and women all across America. That issue is before the court, the United States Supreme Court. The Conference of Judges has said that is anathema to our way of doing justice, that you shouldn't be able to forum shop because you hope the political leanings of the judge that you've filed in front of is going to benefit you. But the Supreme Court has never weighed in on it. The case in front of the United States Supreme Court, the substance of the case is about the FDA's regulation of e-cigarettes. And so that would generally, because the Food and Drug Administration is in Washington, that would normally be filed in D.C. Instead, RJ Reynolds joined together with e-cigarette manufacturers and distributors and created a lobby group in Texas and then used that Texas lobby fake AstroTurf just created artificial group to then bring the case in Texas to try to get to the Fifth Circuit, which they did, in order to try to argue that the FDA had overstepped their boundaries on regulation of e-cigarettes. So the matter doesn't matter here. Yes, the subject matter matters. I mean, it is about public health and children being advertised to and using and being marketed to using these e-cigarettes. But underneath it all, it's a principle about whether the Supreme Court is going to finally stand up to forum shopping and stop it. And so we don't have, in this term alone, I'll give you an example. The United States Supreme Court, this term alone, we have 11 circuits, 12 in total, appellate circuits in our federal system. A large percentage and triple any other circuit of cases coming up to the United States Supreme Court are coming out of Texas and the Fifth Circuit, Texas and Louisiana and the Fifth Circuit. It's disproportionate and disproportional to the rest of the country. And it's because those are the judges who are so MAGA, so right-wing, so Federalist, that they're willing to issue nationwide injunctions. They're willing to overturn Supreme Court precedent and challenge the will of the people more than any other circuit. And that just shows you that's the symptom of forum shopping. The disease is the forum shopping, and that's what the United States Supreme Court is going to have to decide on. And that's going to be in this case, which we will cover here on Legal AF and on Unprecedented, a show that I do with Dina Dahl once a week about the United States Supreme Court. I'll give you another example. When the United States Securities and Exchange Commission, the SEC, tried to regulate and had new disclosure rules for private equity and hedge funds, that would, again, SEC based in Washington, D.C., maybe you could argue New York, the business capital of the world, but because lobbying groups were set up in Texas for these industries, it gave them a direct route to Texas judges and the Fifth Circuit. I mean, for tobacco, back to the tobacco case with RJ Reynolds, there's really only 2 courts and 2 circuit courts that have ever been involved with tobacco regulation. One of them is D.C. because of the FDA's location, and the other is North Carolina because that historically was the home of our tobacco industry and of RJ Reynolds. So the Fourth Circuit, which again is more moderate or leans a little bit to the left for the North Carolina filed matters, and the D.C. Circuit for those filed in D.C. But they hated that strategy. So they started to form groups, fake groups, to lobby in Texas to do the Texas two-step that I just identified. And now the United States Supreme Court is going to have to weigh in and get their opinion. We know what the Judicial Conference of the United States has said, which is it's wrong, it's frowned upon, don't do it. But, courts, including in Texas and Louisiana, have said, yeah, that's an advisory opinion. We're not going to stop it. I mean, so when they see as a gatekeeper that a case we call it venue. Venue is the location for the case. It has to be properly venued, and the court has to have subject matter jurisdiction and has to have personal jurisdiction over the parties. So it's like 3-level analysis at the very beginning of a case. Does the federal judge have jurisdiction? Is this the subject matter of things that federal judges decide? If it's a civil matter, it has to be either a federal question, meaning it arises under the Constitution or federal law, and or it has to be between people of entities of 2 distinct states, complete diversity, we call it, plus a certain jurisdictional amount in order to get into court. That's the subject matter jurisdiction analysis. The venue analysis is this the right court? We get you're in federal court, but is this the right federal court? And judges need to be rigorous, and litigants need to make judges rigorous to evaluate whether this is the proper venue for the actual, is this the right courthouse? Should it be the courthouse down the street or in another state, and therefore it gets transferred by the judge? I've been involved with cases where I argued that a case was improperly transferred, let's say in California, and belonged to New York. It was able to obtain an order of transfer, federal to federal, California to New York for the case. As long as the receiving court, the transferee court, has personal jurisdiction over the parties. That means that the parties are properly sued in that particular state or jurisdiction because of they've agreed to be sued there. That's a consent to jurisdiction, or because of the facts underlying the dispute or the law makes that state the appropriate place, and that the litigant should have anticipated that they would be hailed into court in that particular state. There's a whole constitutional minimum contacts analysis that goes with, are you being dragged into a court that you shouldn't be dragged in, or one that you expected that you should have been sued in, especially if you're a resident there or doing business there. That's the 3 levels that have to happen. Most of that, at least one of those levels, is not happening in Texas. Let's be frank. Judge Kaczmarek is not doing a proper venue analysis to say, this looks like forum shopping, I'm going to dismiss it. He's welcoming it. Look, that's his reason for being. He was picked to be this judge, just as Gorsuch and Kavanaugh and Amy Coney Barrett were picked for a particular purpose, which was to implement the Federalist agenda and overturn years of constitutional precedent protecting progressive values. That's why they were picked. People forget the United States Supreme Court. We've had 75 years of Republican control. But that's not our point. We're okay with Republicans and conservatives. We're not okay with hand-picked people who were just put on there to implement against the American will a Federalist agenda. That's what we're watching. So let's see what the United States Supreme Court does. Follow me here on Legal AF, the YouTube channel. Take a minute, hit the subscribe button, come right back. We'll be here. We're trying to get to 400,000 before January is over. Well on our way. I think we're at 385,000, but don't take it for granted. If you haven't subscribed, hit that subscribe button. And then we're going to get hopefully to 500,000 by the end of February. That's our goal. And then we go from there, onwards and upwards, up to 1 million. I'd like to get to 1 million before our 1-year anniversary. We're getting there with your help only. So, and then follow Unprecedented, a show I do with Dina Dahl, here on Legal AF exclusively at the intersection of law, politics, and the United States Supreme Court. So until my next video, I'm Michael Popok reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.